call the meeting to order. We have a quorum. So this is the meeting of the City of Green Bay Ethics Board for Wednesday, January 6, 2021 at 5 p.m. We've got roll call. And Lindsay, are you going to take roll call or do we just do it by the Zoom?
I certainly can. Sorry, just making sure we are recording. Oops. Okay, sorry. Here we go. I apologize.
No problem.
Little rusty. It's actually, all right, I'll just do it by, oh, I know why. Okay, sorry. Figured it out, guys, don't worry. Alder Kelvin.
Okay. All right, it's a new year, new you.
Right? Alder Galvin is here. Attorney Vandekessel.
Here.
Interim Director Renier Wig.
Present.
Mr. Weinschenk.
Present.
We have a quorum.
All right, very good. And welcome to the other participating alders as well. Next item on the agenda is to approve the agenda for this January 6, 2021 Ethics Board meeting. Is there a motion to approve? Well, let me ask this. Any additions or corrections or modifications to that agenda? None. So is there a motion to approve?
Motion to approve.
We have a motion and I will second. We have a motion and a second. Again, any modifications? Otherwise, all in favor signify by saying aye.
Aye.
All right. It looks like motion carries. Item D, approval of the minutes from the December 10, 2020 Ethics Board meeting. And you should have all received those minutes this afternoon. Are there any additions or corrections to that document? And is there a motion to approve?
Motion to.
All right,
Go
we
ahead.
have a motion. We have a motion we have a motion and second. All in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. On to regular business. Item number 1 is hearing on second ethics complaint against Alder John Vanderleest filed by Mr. Tarl Knight, received on December 4, 2020 under the City of Green Bay Code of Conduct for elected officials. And I would note in connection with this, it's in your packet, that there was also a motion filed by Attorney Miller on behalf of Alder Vanderleest that it was also in your packet.
Just a clarification, that actually was not in the packet. We just received that a couple days ago, so that was emailed to you. I think might have just been yesterday, or yes, I was going to say or Tuesday, which was also yesterday. So
yes, very good. All right, so that is on the agenda, and I think, Lindsay, at this point, I would turn this over to you to give us an explanation as to where we are with this.
Sure. Just give me 1 second. Joanne's in the waiting room. Here we go. Our office reviewed the complaint, the second complaint from Mr. Knight, and presumably you all read it. It concerns allegations that Alder Vanderleest committed an ethical violation when he did not recuse himself from a procedural vote at council concerning the disposition of Mr. Knight's first complaint against him. Our office's role is in this process, at least initially, is to check the complaints for sufficiency based on the requirements that are found in the Code of Conduct. So there are certain requirements that every complaint has to have, and we really just do a baseline analysis to make sure that those requirements are met. A review does not extend to an analysis of whether the allegations in the complaint, if true, would constitute a violation of the ethics code that would be within the jurisdiction of the ethics board. In this situation, Mr. Knight's second complaint does meet the minimum requirements for complaints under the code of conduct, but the conduct complained of does not fall within the ethics board's jurisdiction. Mr. Knight's allegations do not raise an issue of ethical propriety, but rather a procedural question, and procedural questions and actions of governing bodies are within the purview of the courts for review and not within the jurisdiction of the ethics board under the code of conduct. So staff's recommendation would be that this get dismissed.
Okay. Any questions from any of the board members of Attorney Mather on the issue she presented? Okay. And I think what was just addressed really goes to the heart of the complaint, and it does not really get to the motion that was filed by Attorney Miller, but maybe dispositive of that motion based on recommendations from the law department. Attorney Mather and I discussed this. I'll be clear about this. We discussed this afternoon and went through exactly what she just reiterated about the jurisdiction of this board. And I would say from my point, putting on my lawyer hat, that I've been down this path before in other situations that I've represented municipalities, and I would fully agree. And I also had some concerns as to the scope of a issue concerning recusal when it comes to procedural matters rather than substantive matters. That's really an issue that I don't have an answer to. I did deal with it some years ago, and I could not find my earlier opinion in my review of this. But from what Attorney Mather has said, I guess I would say that I wholeheartedly agree based on my understanding of the law and the reading of our code of conduct. So I see that Mr. Knight had raised his hand. We don't have open discussion at this point, but we could entertain a motion to open the floor and allow him to address the board if you would like.
Motion to open the floor.
All right, we have a motion. Is there a second? And we have a second. All in favor of opening the floor, signify by saying aye.
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 Floor is open. Mr. Knight, what was your question?
Can you hear me all right?
Yes, we can. I can.
Great, thank you. You know, and this might be a question for Ms. Mather or anyone who might be able to answer it, but when you say this is a matter that might be best addressed in court or through the courts, what exactly, can you refer to what exactly you're talking about there?
Sure. So, excuse me, if somebody wants to, for example, if you wanted to challenge the propriety of a vote or of the action taken by council, you can do that in circuit court, and that would just be in action, like a civil action through the courts, rather than what would be a quasi-judicial action here in front of the ethics board. So that's a mechanism that already exists in the courts. And so we wouldn't, they would have that jurisdiction. The ethics board would not.
Okay, well, thanks for clarifying. Obviously, new, you know, to having experienced, you know, firsthand something like this in a matter that I was directly involved with. So wasn't exactly sure how to, you know, how to go about holding this sort of thing accountable. So thank you.
Any other questions while the floor is open from anybody else, any of the other alders? Any comments? All right.
I would make a comment to Mr. Knight. I know of some alders and not alders plural, but a alder and a Brown County supervisor that actually faced charges, and this is several years in the past, for not recusing themselves on a vote that benefited them. It doesn't matter what the outcome was, but they did have charges that were filed through the district attorney's office. So anyone can file that complaint if they so choose.
Yes. And unfortunately, I have represented municipalities where they're where I was involved with the village president was charged criminally for violating a similar rule. So, but that's the jurisdiction of the courts. So, all right. Hearing nothing further or no further questions, I would entertain a motion to close the floor.
Motion.
Looks like a motion by Alder Galvin. Was there a
I'll
second?
second, Aaron.
Yeah, okay, we have a motion and a second. All in favor of closing the floor signify by
Aye.
saying aye.
Aye.
Aye. Any opposed? Hearing none, motion carries. Floor is closed. So we've got the recommendation for item number 1 on this complaint by Mr. Knight that the complaint be dismissed for a lack of jurisdiction. I would make that motion that we dismiss that complaint on those grounds. Is there a second?
I'll second that.
I have a motion and a second. Any further discussion or questions for Attorney Mather before we vote?
Oh, I'm sorry, Alder, Attorney Vandecastle, it was bound to happen. Can I raise that other issue that I had broached with you
Oh,
about
yes, go
our
ahead.
review of just before we dispose of this item entirely? I also wanted to ask the board for input regarding whether it would be appropriate to broaden the authority of the city attorney's office with respect to doing that initial review of complaints. So rather than just looking for, does it meet those basic requirements of the code of conduct, which is just the complainant's information, the name and position of the official who is the subject of the complaint, the nature of the alleged violation, including the specific code provision allegedly violated, a statement of facts of the alleged violation, including the specific dates on which the violations allegedly occurred. So right now we just do, are those 5 things, can we tick off those 4 boxes? But as I mentioned previously, we don't go further than that and look at would those allegations, if true, constitute something that would fall within the ethics board's jurisdiction. And so our office would request that the board grant us the authority to review the complaint for the adequacy of the claimed violation, in addition to those base requirements that are in the code of conduct. And the understanding, of course, would be that we will liberally construe complaints in favor of the complainant, and the complaints would simply be returned to the complainant to correct any errors prior to them reaching the board, so that we can sort of streamline this process going forward. And also, just as a side note, we do anticipate that our office's role will be spelled out more directly in the ethics code revisions when they come around. But we're asking for this as kind of a stopgap for the interim to kind of, like I said, just kind of make sure that the ethics complaints that we're bringing before you are ones that have merit and that will not just need to be dismissed for a lack of jurisdiction.
Okay. What we'll do is we'll take a separate vote on that after
Sorry.
this. But while we're on the topic, before I lose my train of thought, what I'd like to suggest is, I have no problem with that process, but to be honest, I kind of like the process we've gone through tonight, where so you've gone through and you've made the initial determination that the complaint that was filed meets those basic requirements to get it in front of this board. But once it got in front of the board, there was that second review that determined that there was a jurisdictional issue. From my perspective, I would like the ability to do what we've done tonight, is to have this meeting and then for your office to explain to us, to all of us, why there is the jurisdictional issue, and give complainants like Mr. Knight the opportunity to inquire why we've made that or why your office has made that jurisdictional determination. I think that provides a more open and transparent view of what's going on here, so that it doesn't just get run through your office and then it never gets to the board. So again, I have no problem with that review, but I just think that it should come to this board when it comes to actually dismissing the complaint, because as it develops, there may be an opportunity for a further discussion that may change some of that. Not likely to do that, but it might. But I like the opportunity for all the parties to have a chance to weigh in on the secondary jurisdictional issue. So that's my 2 cents. So yes, Alder Galvin.
And I'm going to agree with the chair wholeheartedly. I think the transparency and the ability for the common person who maybe doesn't have the benefit of lease or the ability to afford legal expertise can have the situation explained to them, and also the complainants, whether they may realize that there's more information or something that they didn't quite come across in the complaint. And like the chair said, it gives an opportunity for them to address some of their questions and concerns. And I think for both sides, I think that's important, because now this is public, it's transparent, it's recorded, and anyone that thinks there's someone's getting favoritism on one end or the other, it's right out in the open for everyone to see exactly what happened here. Thank you.
All right. So we are back to the question on the motion to dismiss. We had a motion and a second. So I believe we're ready to take a vote on that motion. Unless there's any further discussion, particularly to that motion. Hearing nobody raising their hand or waving around, all in favor of the motion to dismiss Mr. Knight's complaint on the grounds set forth by Attorney Mather, signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. So now, based on what was also raised by Attorney Mather, is there a motion to provide the law department with that additional authority to review the jurisdictional aspects of a complaint that meets the interim requirements to sort of get in the door?
With the caveat that it still would be presented to the committee.
Yes.
Yes, I would make a motion to have that happen.
All right.
Second.
And we have a motion and a second. Any further discussion or questions?
So I just want to clarify for the minutes. So the initial review would remain the same. The complaint would get on the agenda, and then prior to that first meeting, our office would conduct the jurisdictional review and then present our findings on that front at the meeting on the that the complaint is on the agenda.
Absolutely. And again, I think that makes sense in terms of how this all unfolds, because usually this first meeting tends to be more of a scheduling meeting to set a time for the actual full-blown hearing, and any procedural things that need to be done beforehand, like motions and those sorts of things. So if we can get to that jurisdictional issue right at the front end of this, we can expedite the matter that way. So that makes sense. So we have a motion and a second. Any further discussion or questions? Hearing none, all in favor signify by saying aye. Aye.
Aye.
Any opposed? Hearing none, the motion carries. Very, very well. So item 2 on the regular business part of the agenda was deliberations on the complaint. That's already been taken care of by these motions and the motion to dismiss. Item 3 is consideration of possible action on a request for confidential advisory opinion from an official pursuant to Wisconsin statute section 1959 sub 5 and the Green Bay Municipal Code section 1.90 sub 9. Attorney Mather, I guess I would turn this over to you again to deal with this issue because there's been some developments.
Sure. So very first of all, these requests for advisory opinions per statute are to be kept confidential. We have received, unless that confidentiality is waived by the person requesting the advisory opinion. We have received a waiver from Alder Vanderleest, well, from Attorney Miller on behalf of Alder Vanderleest, signed by Alder Vanderleest. I emailed that to the board this afternoon. That states that he is waiving confidentiality with respect to this request for the advisory opinion, and that we may therefore discuss it in open session and that it can be discussed on the video recordings of the meeting and that sort of thing. So to kind of, as a starting point, I just wanted to get the that procedural issue out of the way, that we have in fact received a waiver, and we can proceed with discussing it in open session, even though typically these would be discussed entirely in closed session. Just for those who, the questions that were asked were only sent to the board members, again, because it was going to be confidential. So for just to kind of fill in the gaps, the questions pertained largely to what the proper actions, I guess, are for Alder Vanderleest with respect to votes on the disposition of the first complaint by Mr. Knight against him. And so when under the state statutes, whenever somebody asks for an advisory opinion, there really isn't a mechanism for our office to be a gatekeeper. The questions automatically go to the board. So that's why it automatically ended up on the agenda. But reviewing this one also, these questions about an alder's obligations on future votes and those sorts of things, these are not appropriate subjects for advisory opinions from the ethics board. Such questions should actually be directed to the city attorney's office, as we serve as counsel for all of the alders, rather than being the subjects of advisory opinions. The propriety of voting on an issue will depend on the individualized circumstances of the alder, and it is for the alder, not the city attorney or the ethics board, to determine whether they are the alder themselves is biased in a given situation and therefore needs to recuse themselves. So typically what we do when we get questions about potential conflicts or whether there's a need to recuse oneself, we provide the alders with the legal standards, and the alders then have to make the decision as to whether there's bias or a conflict of interest for themselves. And that's not something that we as an attorney's office would be dictating to them, and certainly not something we would expect the ethics board to be issuing an advisory opinion on.
All right, so interpreting that, my understanding is that we would be in a position to move to refer this matter to the law department for further processing?
Yes, and just to clarify, our office will not be able to provide essentially yes or no answers to the questions that were asked. We will be able to provide the standards for when it is appropriate to recuse oneself, and then it will be up to Alder Vanderleest in this situation or any other alder in any other situation to apply those standards to themselves and decide whether they need to recuse themselves.
Right. All right. So yes, Alder Galvin.
I guess I was kind of surprised that this question was being brought before this committee. I mean, when I started as an alder, I knew nothing about being an alder per se. There was no training or anything like that, but that was one thing I knew about that I had to check. And I have availed, the city attorney's office has been very helpful on many occasions when I've had questions about whether I should be recusing myself or not. So I'm kind of surprised that we're even considering this at this time. But I agree with Attorney Mather that they've always been very helpful and they've always been very available. So.
All right.
Well, and
So-
I'd like to just add that we just voted that the Ethics Committee does not handle these complaints. They go to a different portion, right? The circuit court. So I don't know how we'd answer these questions as an Ethics Committee and then not be able to act on the prior complaint. Right?
Yeah.
Didn't we just vote to say that
Yes.
we don't handle these? But this is like,
Right.
we're asking
So-
to handle them.
All right.
And
So
these two matters are
will-
undeniably connected. I think that's made clear in the request for the advisory opinion that this request is connected to the second complaint. So I think you're absolutely correct.
And I think they're great questions. I would hope that they'd get some guidance with regards to these things. You know, they're good questions to ask, I think.
All right. Any further questions for Attorney Mather? Otherwise, I will make a motion that we refer the request for this confidential advisory opinion from Attorney Miller on behalf of Alder Vanderleest to the Law Department for review and response.
Second.
We have a second. Any further discussion or questions? Hearing none, all in favor signify by saying aye. Aye.
Aye.
Any opposed? Hearing none, the matter is approved and will be referred to the Law Department for further processing. And because of that, I guess I would just note from my understanding procedurally, this matter would not come back to this board at any time in the future for any report or update or anything like that. It would be handled entirely in the Law Department between that department and Mr. Miller and Vanderleest.
That's
Right.
correct, although I would clarify that it really would be between our office and Alder Vanderleest and not involve Attorney Miller, because this is our office giving direct advice to our client with respect to their professional duties as an alder.
Okay. Very good. Point well taken. All right. Then it looks like we are ripe for adjournment. Is there a motion to adjourn?
Motion.
A motion second. I will second. So motion second. All in favor of adjournment signify by saying aye. Aye. Any opposed? None. We are adjourned. Thank you all for your time tonight, and Happy New Year. Stay safe on this very unfortunately sad day for our country, but let's all hope things can rectify themselves shortly here. Well,
Bye-bye.
Thank you all.
good night.